Agora.
Bom dia, senhoras e senhores.
Good morning, ladies and gentlemen. Today we are going to start our fourth and last day of the International Insolvency Conference of IWIRC Brazil, which is a network that extends throughout 4 continents for professional development and networking of its members. This is an event made up mostly of members from our institute that are known for their experience in solvency. You can watch this event in English and Portuguese in our YouTube channels. And I also would like to thank the sponsors that have allowed this event to become possible. Our Platinum Isolati Advogados, Felsberg, Galdino Coelho, Lefosse, Machado Meyer, PG Law, Pinheiro Neto, Sacred Lot, Zini Freire, and Peirano Law Firms. Our gold sponsors, Duarte Forcel and Paoli Bobino and Barros Law Firms, and our silver, AJ1, Judicial Administration, Bioc Empresarial, Bumark Advogados, Faneca, Moraes Júnior, Tayo Schecker, Saluce Marangoni, Parente Jabur, Ex-Lege, Judicial Reorganization, Siqueira Castro Advogados, Tintânio Capital, Zapaz Administração Judicial. And our institutional supporters, the CMR, the Center of Women in Corporate Restructuring, the FONAGEM, the National Forum of Corporate Jurisdiction Courts, EBA-JUD, the Brazilian Institute of Insolvency, BDE, the Brazilian Institute of Corporate Law, IRIB, the Brazil Reorganization Institute, and JPG, the International Association of Portuguese-speaking young lawyers. I would like now to call Liv Machado, partner at the Zini Advogados in Sofela and chair of IWIRC Brazil, to start the panel. Good morning, everyone. Today is the last day of our international conference of IWIRC Brazil. We are very happy to be here today. And it's going to be an incredible panel about transborder insolvency. We are also going to have a panel on indebtedness. And today we have Brazilian members and some of our international stars of IWIRC, and we're very happy to see that. And I've made an introduction of our institute in the first day of the event, and I would like to invite you to get to know the institute, visit our website, and join us. We are an international organization, and those of you that have seen our videos and our social media, you can see that we have over 50 networks globally, and our main purpose is to promote professional development, especially of women in this area of insolvency. And we have lawyers, judges, prosecutors, accountants, all the careers that are related to insolvency and restructuring. And as tracing, we have a lot of members that work with that. So it's very good. We will be happy to have new members and supporters. And once again, I'd like to thank our supporters and sponsors mentioned by Fernanda. And then at the end, those of you that have interacted the most in the panels in the last days will win today a great kit. It's very nice, and I want to show it again. We have I work cup, and we also have some gin, because of course we also need to celebrate. And our partners have also sent 4 copies of their book on corporate restructuring, and one of the organizers of this book will be on our panel. And so whoever has made the most interactions throughout the whole event will win this kit. So those were my starting words, and now I hand the floor back to Fernanda. Thank you, Liv. And with no further ado, we want to start our first panel, which is going to do with the UNCITRAL Model Law in Brazil, its peculiarities and perspective of practical implementation, COMI, and automatic stay. We are going to have Paula de César, a lawyer at Duarte Fossil Law Firm and member of I Work Brazil. We're going to have Isabel Picot, partner at Galdino and Coelho, an Insolvency regional coordinator of I Work Brazil. We have Diana Miller, a counsel at UNCITRAL Law and Latin America chair of I Work International. We have Leisa Blanco, partner at UNCITRAL Law and chair of I Work International. We have Sheila Nan, partner at Hajag & Tan Singapore, Insolvency and vice chair of I Work Singapore. All over to you. Well, I want to thank Liv Machado for this introduction and this invitation. It's a great pleasure to be here. I've been a member of iWork since 2019, and to me, it's incredible to be part of an association made up of women. It's an inspiration to see these women that are references in the area. Women are the ones that make the difference in this corporate world. So I want to congratulate our association I Work for these great panels. So I'm going to speak a little bit about our theme, a general overview about the UNCITRAL Model Law, and then the topics that we're going to talk about with the panelists. We're going to talk about 3 topics. I'm a lawyer at DAF law firm that specializes in asset tracing. So in the area of bankruptcy, we work with the administration of assets, and we see a lot of foreign jurisdiction somehow protecting the debtors. So to have a greater cooperation between the companies, this model law was passed to have these collaborative systems. And in 2004, guidelines were published for implementation for this law. And the purpose here is to have more simplified procedures for trans-border insolvency procedures. And so at the moment, we have 49 countries that have adopted internal laws based on the model law. We have Singapore, United States, and now recently Brazil, which we came into effect in January of this year. So we're going to speak a little bit about these peculiarity, and our panelists are going to answer questions. We have these credible women here with us, and we're going to talk about the conditions for admitting foreign procedures, the consequences of that acceptance, and what we can have in terms of evidence and due upon acceptance of these foreign processes. So now I'm going to switch to English, as our panel is made up mostly of international lawyers, and there is Portuguese translation available.
First of all, I would like to welcome all the panelists, Sheila, Nayana, Leis, and Isabel. I'm looking forward to hearing all of your perspectives on the UNCITRAL Model Law over the course of our conversation today. So, Sheila, are you hearing me?
Yes, hi, Paula.
Hi, Sheila. Let's begin with you, Sheila. Sheila, what can you tell us about who can ask for the recognition of a foreign mail proceeding?
Yeah, thanks very much, Paula. So just a brief background about Singapore as well in terms of the model law. It's also very new to us. We only adopted the model law in 2017. So we are learning along the way, just like how Brazil is, in terms of developing the jurisprudence. So in terms of recognition of a foreign main proceeding, who can ask for it? It's really a foreign representative who is able to do so. It is defined in the UNCITRAL model law as a person or body. So it doesn't have to be just an individual, but it can also be a corporation, so a company, including one appointed on an interim basis. So even if it's not a final, position yet, and only on an interim basis pending the disposal of the application to place the debtor into an insolvency proceeding in the home country, that is also allowed as a foreign representative to make that application for recognition. What's important in Singapore, it's a little particular in terms of Article 4, it's that the court in Singapore only has jurisdiction in relation to recognition of foreign proceedings if the debtor has been carrying on or is carrying on business in Singapore. But that is defined quite broadly. It doesn't have to be really in terms of operations, but at least there must be some administration or management of the company, or otherwise there is some property situated in Singapore before the Singapore courts have jurisdiction. Another thing also, of course, is always a catch-all. So notwithstanding that the company, the debtor company may not have property or may not be carrying on business in Singapore, there is also the ability for the court to consider if for whatever reason it is the appropriate forum to consider a question or provide the assistance requested. The court may also exercise its jurisdiction in recognizing the foreign proceeding. So that's just something that I wanted to sort of highlight, that's a little different in Singapore. And going to foreign representative, that's also quite important because it's only the foreign representative of the insolvency proceeding which can make the application. And there are actually important criteria to fulfill in making that application, because when the application is made, it must be accompanied by various items. So this is one, a certified copy of the decision commencing the foreign proceeding. So there must be something that confirms that in the foreign country, the proceeding has been commenced. Two, it could also be a decision that appoints the foreign representative. So an order of court, for example, that has been made to appoint a foreign representative, or it could be a certificate from the court to confirm the existence of the proceedings and appointment of foreign representative. And in the absence of the above court evidence, any other evidence that might be acceptable to the court. And that's important because there are some insolvency proceedings that are out of court that are nonetheless collective proceedings that fall within the scope of the model law. And one example is that in Singapore. So in Singapore, what we do have in relation to schemes of arrangement, and a scheme of arrangement is where creditors come together, and agree to a compromise. And this is usually a debtor-led restructuring, the scheme of arrangement proceeding. And that in itself has been recently recognized overseas as also a foreign proceeding that falls within the scope of the model law. And this was back in 2019 in the UK courts for HNCS holdings. And this is where in Singapore, what had happened was in relation to the scheme of arrangement proceedings, to give the company breathing space before the company can actually propose that compromise and that scheme of arrangement, it can make an application to court for a moratorium. So by virtue of that moratorium, and this is what we call in Singapore the Section 64 moratorium under our Insolvency, Dissolution and Restructuring Act. That in itself represents a proceeding in relation to scheme of arrangement, and that's been accepted as an insolvency proceedings overseas. And in fact, in ProSafe SE as well, that's also the moratorium that has been recognized. That was given in Singapore. But I also just wanted to highlight that even if there may be concerns about the fitness of the foreign representative in the jurisdiction where recognition is sought, that model law actually does not empower the court to displace the appointment of a foreign representative. So the model law only allows for recognition, but doesn't allow the court recognizing the foreign representative to make any decisions to replace the foreign representative. That is only a question to be determined in the home jurisdiction of the foreign proceeding. And that was interesting because that was something that came up in one of the Singapore cases, where the Singapore courts commented that even though it had serious concerns about the propriety of the foreign representative taking charge of the assets here in Singapore, because, for example, in relation to that particular individual, he was an undischarged bankrupt. And typically in Singapore, an undischarged bankrupt cannot actually be an insolvency practitioner and cannot actually lead the cases. But notwithstanding that, the court said that, unfortunately, I can't do anything about it. I have to once I agree that the foreign proceeding should be recognized, that foreign representative is recognized as the foreign representative to take charge of the matter. Back to you, Paula.
Okay, thank you, Sheila. So, Isabel, could you tell us what kinds of proceedings could be recognized as foreign proceedings under the model law?
I'm muting myself. Can I begin in Portuguese just to make the introduction?
Okay.
Porque eu gostaria de agradecer.
Yeah. I just like to thank in Portuguese, especially Liv, for her leadership in this institution, such high quality. In 2019, I joined IWIC, and I never imagined that it would become such an incredible network of women. So that's why I wanted to start speaking in Portuguese. After all, this is the Brazilian chapter of IWIC, and we see all the work being done by the members for this event to happen and to be able to gather all of us in this community to talk about this area that is very dear to us. So I want to give a special thank you for IWIC Brazil for all the help that we've had over the past years, and to say how happy I am to contribute and to be here today. So I'm very happy to be on this panel. I admire all the panelists. They are incredible women, and they are truly my inspiration. So thank you, IWIC, especially Liv Machado, for all her work.
With Sheila, because we were colleagues together back 2019. We were in Sao Paulo, and we had classes, and we could share memorable moments, right, Sheila? And could deeply, I think, study what the insol issues and what we are going to be discussing here today. So I would like to say that I'm very happy to be here with you today. It was also in our class, and I hope we can meet in presence soon. So to your question, I think we discussed a little bit about how Brazilian bankruptcy law incorporated the model law, adopted the model law with the law for 14,112 beginning of the year. So we have now in Brazil the UNCITRAL Model Law framework to apply to cross-border insolvency proceedings. It doesn't mean that we didn't have cross-border insolvency proceedings in Brazil before, but we didn't have the legal certainty that we now have through the incorporation of the set of very important rules that will guide the courts in Brazil when you have foreign elements in this kind of disputes where we have assets of foreign that are located in Brazil, or where when we have creditors, foreign creditors of cross-border insolvency based in Brazil. So I'm very confident that we made a very big evolution through the incorporation of the model law. And as you described it, the model law has its own set of rules. We incorporated it substantially, but I think the most important thing to discuss, even before going to the definition of the foreign proceedings itself, is to understand why is it relevant to understand the concept of a foreign proceeding. And I think the idea came up when we talk about the dichotomy between the territoriality and the universalism approach. We had this debate for a long time, and we still have this debate for a long time. We had this debate in Brazil. I worked in a case in 2018, 2019, where in which this discussion of territoriality and universalism applied to the case. But the UNCITRAL Model Law came to overcome this dichotomy. The territoriality, trying to summarize, brings the idea that each country has its exclusive right to govern within its borders as a result of the state sovereignty. So it's a way to respect the sovereignty, and several jurisdictions, as a result, would end up handling several insolvency proceedings with regard to international company or group of companies. And the universalism approach, on the other hand, will be a kind of interplanetary court concentrating all the disputes in connection with the company undergoing the financial stress, and lots of sovereignty discussions arise because of the universalism approach. And like both theories didn't actually work to solve the issues that arise because of this dichotomy. Frauds or debtors that move assets to different countries to attract the best jurisdiction applied to its insolvency proceedings. So the solution, if we might call it the solution, we call it the solution, it was to harmonize both territoriality and universalism with the post-universalist approach, or the mitigated universalism. And through the post-universalism approach, the definition then of the foreign proceedings divided into the foreign main proceedings and the foreign non-main proceedings then became very relevant to build up, I think, the solution to respect sovereignty of each national jurisdiction at the same time to grant efficiency, economy, legal certainty to insolvency proceedings. And why is that? It's because the way the model law is structured, and now the way Brazil incorporated and will apply and is applying it to our insolvency proceedings, will seek to identify the most relevant jurisdiction when there is cross-border insolvency situation. which one is the most relevant jurisdiction, we will discuss, but this would be, in concept, in essence, it would be the foreign main proceedings. And at the same time to apply a court-to-court cooperation between, among the foreign main proceedings and the foreign non-main proceedings. Can be more than one foreign main proceedings that are somehow impacted by the insolvency proceedings of a company, of a group of companies, and to allow these jurisdictions to recognize the foreign main proceedings and to cooperate to facilitate the communication, to facilitate the cooperation among all of these jurisdictions and to reach, in the end, the insolvency goals. The Brazilian bankruptcy law adopted the same concept of foreign proceedings that the model law provides. I can read to you, I wrote it down here, because I think it's a very plain language to explain the idea of a foreign proceedings. Means a collect judicial administrative proceedings in a foreign state, including an interim proceedings pursuant to a law relating to insolvency, in which proceedings and proceeding the assets and affairs of a debtor are subject to control or supervision by a foreign court for the purpose of reorganization or liquidation. So I would like to highlight two main concepts related to foreign proceedings. First, it is connected to collective proceedings. So it's not applied to individual enforcements, for example. We are talking about collective insolvency proceedings. And it also brings the idea of a foreign element. As I told before, when we have assets, affairs of a company in connection with subject to foreign authorities. So the idea of a foreign main proceedings encompass both, I think, these both very relevant concepts. But then it goes to probably what we need to understand to apply the UNCITRAL Model Law correctly, which is the foreign main proceedings. And the foreign main proceedings, in accordance to the law, means the foreign proceedings take place in the state where the debtor has its center of main interest. So the center of its main interest is it's well known as the COMI of a company. We will discuss this later on in this panel, but it's very important to understand where is the COMI of a company to identify where is the foreign main proceeding. So if we have two countries, for example, in Brazil we have, and we are going to talk about this here in this panel, in Brazil we have lots of cross-border insolvencies with Chapter 15 cases in course in United States, and US courts apply model law substantially with some additives, but substantially as well. So both courts, Brazilian courts and US courts, will be able to, looking at their own insolvency, cross-border insolvency framework, to identify, okay, here is the main jurisdiction, the foreign main proceeding, and here is the non-foreign main proceedings. And the concept, the relevant concept to understand, to define which one is the main and which one is not the main proceedings would be the COMI of the company. And the foreign non-main proceedings will be exactly foreign, it's a foreign proceedings other than the foreign main proceedings taking place in a state where the debtor has establishment. And in Brazil, we incorporated the company with this minor change, including the name asset. So in the law in Brazil, Brazilian bankruptcy law, will say that the sites and establishments, the assets, the location of the assets will also drive the concept of annulment proceedings. So I think the following up understanding with regard to the differentiation between the foreign man and non-foreign man and its consequences, it's more related to the concept of commi, and I don't want to spoil the next step of our panel, but like I'm happy to clarify any questions with respect to the concept of foreign proceedings.
Okay, thank you. Thank you for sharing, Isabel. So now with you, Nayana. Nayana, does the model law impose any other conditions on the debtors on what debtors are eligible for recognition?
So thank you, Paula. Thank you so much for the question and for being our lovely moderator and organizer of this panel. I also want to take an opportunity to thank Work Brazil. It has been doing an awesome job of organizing these kind of educational events for our members and really bringing women together throughout the industry. So, congratulations to Liv and to the other members of the board for the growing, not only the growing number of members, but I think the growing impact that iWork Brazil has been having on its members. So about the model law and the conditions on debtors. It's interesting, right? I think from a Brazilian perspective, it seems a little bit odd to have a law with definitions, but that's, very standard for our American laws. And I think for other systems in the world, right? Every American lawyer certainly expects to see definitions at the beginning of a law. And so this model law, as it was adopted, in Brazil and as the original text stands, does contain a definition of debtor and who can be a debtor under the law, but it's not a very onerous definition. It simply says that the debtor, the word debtor, anytime it appears in the statute, simply means the person who's subject to a foreign proceeding. Now, the definition of foreign proceeding, as Sheila and Isabel have explained to us, it does have a lot of facets, right? So that's really the important definition under the model law that you have to meet, is the definition of foreign proceeding. But the debtor is therefore anyone who's eligible under that foreign law to be subject to that foreign proceeding, or the subject, I think is the way it's phrased. What happened with this definition in the United States is, I think, an interesting example of what happens with concepts that come from outside of your legal system once the judges within your legal system and applying a country's own traditions and experiences, what happens once those things all interact. So the United States adopted the UNCITRAL Model Law in 2005 and, tried to assimilate it within an existing system that already was available to give recognition to foreign bankruptcy proceedings. And then what happened, this actually wasn't a very early thing, but specifically with the definition of debtor, it was after 2010, I don't remember the year exactly, but a court in the Second Circuit, I think it was our appellate court in the Second Circuit, so that's, coming out of New York, in a case called Drawbridge, decided that, not only would they look at the definition of debtor in Chapter 15, but they would also look at the general definition of who can be a debtor under the US Bankruptcy Code. But that, from my perspective, doesn't make too much sense because you already have one definition. You certainly don't need another definition. And other courts have agreed with me that it doesn't make too much sense. But the original court that considered this issue in the Drawbridge case, they determined that they should consider the requirements under US law to be a debtor. And those requirements include to have a place of business, a domicile, a residence, or property in the United States, right? Which on first blush, and I think in that particular case, it sounded logical to the court that the debtor needed to have at least one of those things. I think Sheila mentioned that there's maybe a similar interpretation is given in Singapore, but Sheila also mentioned that Singapore can allow the lawyers to come in and argue other reasons why Singapore might be an appropriate jurisdiction. And that's really what was missing in the drawbridge decision, was this element of, but there could be another reason that you need to be here because this is a cross-border case. And what are those reasons? As a practical matter, I in my practice see two main reasons that we see with regularity of debtors who maybe don't have property in the US, but they need to be here because they have a cause of action in the US, right? They have a claim against someone who injured the debtor, took assets from the debtor, is holding something that no longer actually legally belongs to the debtor, but we need to bring a claim in order to bring that asset back into the estate. So there's a whole debate now in the United States, and I guess it probably predates drawbridge, but it's become more important because of drawbridge. And the debate is whether a cause of action or a claim is itself property of the estate. And then the second reason that we see debtors often want to come here, even when they didn't necessarily operate here, or the bankruptcy trustee in particular wants to come here, is to investigate, because assets passed through the United States, right? There's information that can be used to trace improper transfers and to bring assets back into the estate again. So, so information is a perfectly good reason or logical reason to want to be here, but it wouldn't be enough under, strictly speaking, what the Second Circuit said in drawbridge. Other courts have either said that they disagree with the drawbridge holding, right? So I think Leiza's arguing that issue right now, and it's up on appeal, and maybe she'll give us a little bit of insight on what might happen in her case, which is fresh. But in some of our past cases, we've had at least some judges in the United States have given an advisory opinion that they don't agree with the drawbridge holding, or that they're willing to interpret the drawbridge holding in a very limited sense. Okay, so you have to have property in the United States. I'm going to consider that cause of action, or I'm going to consider a pending lawsuit. Certainly, one court has considered, okay, well, there's money held by the lawyer. This isn't very common in Brazil, actually, so I'll explain this a little bit. In the United States, it's very common that when anyone engages a lawyer, so when the bankruptcy estate or when the foreign representative engages a US lawyer, they'll pay it's called a retainer, right? That retainer is kind of like a deposit. It sits in the lawyer's trust account. So for purposes of satisfying drawbridge, some lawyers just continue to hold that money throughout the entire pendency of the case, and they hold it not on behalf of the foreign representative, but on behalf of the debtor, right? It has to be the debtor's money. So some courts have said, yeah, I recognize that that's the debtor's money, even though the lawyer's just holding it. It is an asset of the debtor, it's property of the debtor, and therefore, it's enough. And oftentimes it's enough together with other factors, right? So one court considered that the debtor was a borrower on a loan. That was governed by New York law and saw there was sufficient reason to be in the United States because of that. Another court said, okay, there's money in this trust account, plus there's a pending lawsuit involving the debtor, so we need to be involved because of that reason. And so, we have had our whole, this whole saga, this whole side chapter, which is not something that the model law ever intended, right? The model law includes its own definition of debtor that doesn't have anything to do with property in the ancillary jurisdiction at all. And Leiza, I don't know if you want to give us a preview of what might be coming down the pike in your current case.
Sure. Thank you, everyone. Bom dia. Prazer estar aqui com vocês. My Portuguese is limited, but I always like to welcome my colleagues and friends from Brazil. Being in iWork Brazil is a little bit like coming home for me. I wish I was there in person to share with you these thoughts, but I'm happy that we're able to join via virtual means, at least in the interim, and hope to see you all very soon. Thank you, Liv, Paula, Bia, Fernanda, Flavia, all of you who have put this fabulous event together. I'm really, really honored to have been asked to participate with you. In respect to the issues that Diana was just commenting about, our law, despite having been enacted in 2005, our version of the model law is still for many of us who have been doing this for a long time, somewhat new and developing. And in this area of who can be a debtor, or what does it mean to be eligible as a debtor for Chapter 15, we've seen, some what I think is errant case law developing through the drawbridge decision, which in my humble opinion is just simply wrong, to impose the US's definition of who may be a debtor under US law over a debtor that is already qualified as a debtor in a foreign proceeding elsewhere. So that sort of incorrect rationale has led to what I think are cases that try to work their way around these decisions that are not entirely correct, including judges who have to find, in order to recognize a case under Chapter 15, that a right in a contract to venue a dispute is sufficient to establish a property right. You see the judges stretching to make sure that as a common law country, we abide by our precedent. This issue of drawbridge imposes a bit of an even more difficult analysis when you have an individual debtor, because while a foreign representative, who's often a bankruptcy trustee, can give an American lawyer a retainer, and that American lawyer can hold that retainer on behalf of the company, because the company is still operating or the company is being wound up, but the foreign representative controls the property of the company. When you have an individual presents a little bit of a challenge, because that individual continues living, and what is in their property of their bankruptcy estate is not necessarily what continues to be their property as property of the debtor. So you see the dichotomy of how even a retainer could be a difficult argument for someone like an individual. And I have presently a case that is working its way through the appellate courts. It's on appeal now in the courts in Florida. And it is a case in which the judge correctly, I think, decided in our favor on behalf of the English bankruptcy trustee that, in fact, the requirement of 109, it's under our section 109 of the US Bankruptcy Code, simply just does not apply to a Chapter 15 recognition proceeding, for the very reason that a debtor is already qualified in the foreign proceeding and does not need to then again qualify under US law. Rather, the court found that under Chapter 15, a debtor is qualified under the model law to be a debtor, and did not impose the requirement of having property in the United States or in the area or in the region where the foreign proceeding was filed. So what will happen, I think, is this will work its way up through the appellate system. Potentially, if the opposing party decides to appeal at another level, it may come to the point where we have two conflicting courts. We have drawbridge, which is really the highest level of appellate court in our U.S. system. And if another court of the same level decides differently, we then have what we call the conflict between the appellate courts. And those are the types of conflicts that we see our United States Supreme Court decide on a year-to-year basis. Our Supreme Court only decides about, 40 cases a year, and very rarely do they delve into topics of bankruptcy law. But when two appellate courts have decisions that oppose each other, it's the obligation of the Supreme Court of the United States to determine what the right answer is, because the courts are in conflict. So we might see this issue come up all the way through the system, all the way through the United States Supreme Court, which would be quite interesting from a cross-border model law perspective. So stay tuned for that. I'll keep you posted on what we can accomplish in the pending appeal, and we'll see how it goes.
Okay, thank you, Lisa, for sharing. Thanks, Nayana. So when a foreign representative shows that these basic requirements are met, the court must then decide if the foreign proceeding is located in the jurisdictions that the debtor's center of main interest, the COMI. So regarding this, Isabel, now regarding the COMI, could you clarify what is the center of main interest, the COMI?
Sure. I think we reached the ultimate criteria provided by the model law. and it was replicated by the Brazilian bankruptcy law to determine the principal establishment of a company or a group of company. And I think the model law uses this concept of common to determine like the degree to which the courts of one jurisdiction are obliged to recognize and assist insolvency proceedings commenced in different jurisdictions. As I told before, courts that apply the model law will be confronted with the concept of kami to understand, yes, you are the main and you are the non-main. And sometimes you can have conflict. And we have cases of cross-border insolvency where we had two jurisdictions understand that they have the main proceedings, but it went well. They had a court-to-court protocol cooperation, and even though they both understood that they are the main proceedings, it didn't end up in a messy situation of conflicted jurisdictions. But I think what we need to understand is that the model law doesn't have a clear definition on kami. It only says, and again, I will have to read because I think it's better than me explaining, that in the absence of proof to the contrary, the debtor's registered office or habitual residence in the case of an individual is presumed to be the center of the debtor's main interests. In Brazil, we replicated this idea. We say in Portuguese, país da sede estatutária do devedor will be the centro principal de interesses, the kami. And then I think the most common concept of kami, therefore, is borrowed from the European insolvency regulation, which is a little bit more, I think, deeper. It's deeper than the concept of kami brought by the model law. And it says the kami is generally a place where the debtor conducts its administration of its interests on a regular basis and ascertainable by third parties. This idea of being recognized by third parties, meaning creditors, that place is the kami, it's the center of main interest of a debtor. It's very important and embodied in the concept of the model law. So when you were applying the model law and studying the model law, understanding that both administration of interests and ascertainable by third parties are, I think, the elements that should be highlighted here. But there is a rebuttable presumption that the corporate debtor's kami is located in its registered office. So it's like you first look at where is the registered office. Okay, it's located in Brazil, but it's rebuttable presumption if you look into other factors that will compound in the end this broad concept of kami. So and when a court is analyzing the kami of a debtor, I think several factual elements will come into play and it's going to be a very concrete analysis, case by case. And these factors will be analyzed by the court, and in the end, the court will reach a conclusion where is the kami. And we see it from case law that place of business, registered office, location of assets, where the employees are located, where the board meetings take place, where the decisions of the company are made. Those are some examples of factors considered by the court to identify the kami. In this particular, I think we will resemble how the courts in Brazil apply the concept of principal establishment. I think it's important for our international colleagues to understand that in Brazil, to identify the jurisdiction, to insolvency proceedings, domestic insolvency proceeding, the court will analyze where is the principal establishment of this company. But when we have a group of companies, for example, and we have a few of these elements spread between our large country in Brazil, then the court will say, okay, here I think is where the heart of this company is, where, for example, the decisions are made, where the shareholders are located. Then the court in Brazil will look basically at the same idea of these elements to establish the principal establishment of a company and to identify where is the principal establishment of this group in order to entertain jurisdiction to a specific state in Brazil. I think it's very similar, but what is important for our understanding is that the company will be applied entity by entity, in an entity by entity basis. And in Brazil, we the courts make it in a different approach. The court will look to the group and identify where is the principal establishment of a group. And when a group of companies, and usually when we have cross-border insolvency, we will have a group of companies, we can have an entity pertaining to that group with a common in a place, and another entity from the same group with a common in a different place. And this analysis will be made in an entity by entity, not in a group basis. It happened in Brazil in a case, unfortunately, that I worked with. The court did it differently. The court applying, we didn't have UNCITRAL Model Law. We didn't have the section in our Brazilian bankruptcy law at that time. So the court, there were 18 companies pertaining to this group of companies, 18 debtors, each one with different registered offices, but with operations located in Brazil, with the employees located in Brazil. So we had several elements to evidence to the court that the company of the group was located in Brazil. Nevertheless, the court applied this analysis of entity by entity and applying territoriality, the territoriality theory. The court rendered in the end that companies that had assets located in Brazil would attract Brazilian jurisdiction. It was a cross-border insolvency. And one of the entities was removed from the cross-border insolvency proceedings in Brazil because the main asset was located in India. And then we had ended up with insolvency proceedings with 17 entities with an insolvency proceedings based in Brazil, and one entity had to make a scheme of arrangement in BVI, where the registered office of this entity is located. So I think this is important for us, especially for us Brazilians, to understand that when we're applying CAMI, maybe you have to look entity by entity where the company is located to identify, okay, the company A has foreign main proceedings in the United States, company B will have foreign main proceedings in another place, so the foreign non-main proceedings. And in this case, there was a Chapter 15 connection with the Brazilian insolvency proceedings, and the U.S. bankruptcy court in the end rendered that two of these entities didn't have main proceedings in Brazil, but in Luxembourg, where they had their registered offices. And it didn't impact the insolvency proceedings in Brazil because the secondary proceedings taking place in the United States understood that Brazil was not the main proceedings. And I think this is something that we are going to discuss later on what are the difference when a court, okay, this is main, this is non-main, but like this identification of CAMI and the distinction between between non-main proceedings and main proceedings, maybe it's not so relevant when you have court-to-court cooperation and the recognition and the courts providing reliefs that will protect the debtor, the company in distress, whenever it's necessary.
Okay, thank you. Thank you, Isabel. So, Leisa, can you share with us about the US experience with interpreting and defining the COMI, please?
Sure. And in the early days of our enactment of the model law, this was the area that caused the most litigation, and because the definition of COMI is one that, while similar to the US concept of domicile and principal place of business, it's really not identical. So to one of the instructions, or I guess the lessons learned, is when you have a model law and it introduces a new concept, the best way to try to understand the new law as it incorporates into your existing legal regime is to understand the new law. One of the ways that our courts started to go sort of in the wrong direction was trying to overlay the concepts that we already had in our laws. Like I was explaining, similar to the issue with who may be a debtor and the drawbridge decision, the same sort of began to happen really early on with the concept of COMI, which is not, the definition of COMI is not a model of clarity in the model law. So it leads itself to interpretation, and obviously each jurisdiction will interpret those words and the meanings in the best way they know how, which is the way that they do so internally. So the issues began with Bear Stearns, which was one of the early cases decided under Chapter 15. And the court unilaterally, without anyone objecting, essentially refused the recognition on the basis that a letterbox company of one of the Bear Stearns funds in Cayman did not have COMI, even though its registered office, which was presumptively the COMI, was in Cayman. And so like that began a long line of cases with different judges interpreting the COMI. One judge more recently determined the COMI to be the nerve center of the company. And so the nerve center of a company is not a typical way that you would describe a company, but obviously judges in different circumstances applying the facts of different cases gave their own sort of interpretation of the model law, and thus it began that our cases just sort of went every which way. From my perspective as a practitioner in this area, it's very exciting to be in an area where your law is developing. I think it's going to be fantastic for all of you in Brazil as your law sort of makes its way through the courts and through the different cases. What I learned was that the best way to read and understand the new law is to go back to the guide of enactment, which is really the piece that the writers of the model law and then the subsequent working groups that have worked on the model law have put together for our benefit, so that we can all around the world, in signatory countries and even in countries that haven't yet signed on to the model law, it's the encyclopedia or the Bible for the model law. It tells us what they meant or what they intended when they wrote the law. And then they also provide us key cases that have been decided in different jurisdictions. One of the beauties of this, which I as you might imagine, I love this area of the law, and to me it's very exciting, is one of the ways that you can sort of help develop the law in your country is to argue based upon cases decided in other countries, because that's all that you have right now on the ground level. So in the guide to the model law, you can find ways and cases in which examples are given of how other countries have interpreted the language and the concepts of the model law. So I think from my perspective, that's sort of the lesson I've learned, is go back to the guide and see what they meant. I early on in 2010 handled two large cases of what was the largest market share of insurance companies in the Caribbean. There were 11 jurisdictions involved, and the British American case, it was called, worked its way through the Florida courts, and I was their U.S. counsel. And at that time, in 2010, I argued to the court in my cases that the COMI should be determined as of the date of the Chapter 15 filing, because in our adoption of the model law, the words were in present tense, which to me meant clearly that it was meant to be analyzed as of the date of the Chapter 15 filing. Of course, as you might imagine, a court could have a pending bankruptcy proceeding in the home jurisdiction for a long time before a Chapter 15 ever is filed, because sometimes a foreign representative who initially is appointed a bankruptcy trustee doesn't know all the facts and doesn't know where in the world his work or her work will lead. So sometimes there's a passage of time that in some ways changes the analysis and changes the facts. So the argument that I made was that the present tense language in the law had to require that the court find the COMI as of the date of the Chapter 15 proceeding, rather than as of the date of the home proceeding. At the time, I thought that was a great, it was the right argument and the right result for the case. But as that case was published and cited over and over, the writers of the model law saw that the law in the US going in what they thought was the wrong direction. And several years later, I had a different case representing a bankruptcy trustee from England. And in that case, I had looked back at the guide to the enactment of the model law, which had been revised. And in revising the guide, the model law writers said that their intention was that the determination of COMI be made as of the date of the foreign proceeding, not as of the date of the model law equivalent recognition proceeding. And so that changed everything. And I actually was, that was the basis of my argument to the court in that case, that in that instance, I was seeking recognition and that the court needed to examine the COMI of an individual debtor as of the date of the home proceeding, of the bankruptcy proceeding in the English courts. And it was a different argument completely than what I had made years before in a different case. But I think based upon the guide to the enactment of the model law, it was the right argument. So I think you should take heed of the lessons learned by the US courts and by practitioners like me. And when you have doubt, go to the guide to the enactment and see what not only the writers have to say about what they wrote in the model law, but also how the different courts around the world have interpreted those words. And maybe you can be informed in that regard as to what the right reading is of the law as it relates to the facts of your Brazilian case.
Okay, thanks for sharing, Leisa. So regarding the relief, Sheila, for a debtor company, what are the benefits of applying for recognition of a foreign-made proceeding?
Thanks very much, Paula. So just to add on to what Leisa mentioned, in relation to looking at, the guide, in a different approaches. I was just wanted to say that, in Singapore, as we are learning, and interpreting the model law now, and, we have, lots of cases where we discuss, the US approach, the various different approaches and also the guide. And in fact, when it came to the COMI, in terms of that particular question, what's the date for ascertaining COMI? That discussion actually came up in Singapore. Do we take the US approach? Do we take the European approach, or do we take the Australian approach? And I think it's something that struck with the Singapore courts is that because we take a very proactive, or rather a very quite a supportive approach so far, as we can see, in relation to forum selection. That I think sort of informed the decision to follow the US approach in looking at COMI as the date of the application for recognition. So I suppose it's a combination of the guide, the approaches taken by the various jurisdictions, and also informed by the policies of the particular country as well in terms of recognition. And coming to relief in terms of what the benefits of applying for recognition for a foreign main proceeding, it's important because there are certain reliefs that are provided for in Article 20 that are automatic. In that once the foreign main proceeding is being recognized, these are consequences that arise automatically. So it's not a matter of discretion of the court, but it can't automatically. And that's important in relation to the moratorium. So that's where the commencement or continuation of individual actions or individual proceedings concerning the debtor's property, rights, obligations, or liabilities are stayed in the country where the foreign proceeding is being recognized. Execution against the debtor's property is also stayed, and also the right to transfer, encumber, or otherwise dispose of the property is also suspended. And these only arise upon the recognition of foreign main proceedings, and that's the reason why there is this importance about determining whether proceeding is foreign main or is it foreign non-main, and where the COMI is, and that's why we spent a lot of time earlier discussing the whole concept of COMI. So this is, and the stay of actions, of course, is necessary to provide breathing space. And I think the reason why this arises automatically is because the model law recognizes that if there is a foreign main proceeding, something that's happening outside in a different jurisdiction, breathing space should be given in the other jurisdictions where recognition is being sought. And this is in contrast to the relief that can be sought, in addition to the automatic relief that has been given as a result of a foreign main proceeding that is granted. So, for example, in relation to the other relief that can be granted as a matter of discretion, and this is set out in Article 21, and that's where under Article 21, there's also the provision for the examination of witnesses, the taking of evidence, the delivery of information concerning the debtor's property, affairs, rights, obligations, and liabilities, as well as entrusting the administration of the property in Singapore, so in a country that's being sought for recognition, to the foreign representative, or it could be to another person that's being designated by the court, or any other relief generally that's available to a Singapore insolvency holder. So that's important, in the sense that once it's being recognized in Singapore, then the courts in Singapore will give, the foreign representative the powers to go and compel witnesses, to compel the cooperation of persons who know information about the debtor company to come forward. And that also extends to the delivery of property as well, if there is a case that's being made up on that front. And I think all this is important, in the context of, making sure that there is that, cooperation, that assistance is being given as quickly as possible. So, in terms of the recognition, when we make an application, apart from the automatic relief that's being sought very quick, typically in the first application, the discretionary relief is also being sought. And that's to make sure that, whatever that is required specifically is being obtained as soon as possible. And that may even extend to certain moratoriums in relation to certain action. Having said that, there is a carve-out. So even though that there is a moratorium, the ambit of any stay is only limited to what is available in Singapore. So in Singapore, for example, in the context of liquidation, insolvency proceedings, a secured creditor is allowed to enforce its security. And therefore, even though there is a moratorium, leave will be granted to the secured creditor to enforce its security. And so therefore, even under the model law, notwithstanding the general stay, there's always that carve-out that if a secured creditor intends to take any action in relation to security, leave will be granted, and there will be no stay given to that. And that's something that was recently discussed in the Singapore courts in that context, to make it very clear that in relation to actions that do not fall within the scope of what will be captured in a stay in Singapore, will not be given a stay under the model law. Back to you, Paula.
Okay, thank you. Thank you so much, Sheila. So, Nayana, what can you tell about the scope of the automatic stay in the US?
Sure. Thank you, Paula. I'm just going to pick up, I guess, where Sheila left off, because, you know, with respect to most of the items that are in the model law, it's the same here, but it's broader in the United States. So because, you know, as we've been talking about, there's an overlay between the model law and the domestic law. The way that the model law was adopted in the United States, it incorporated American law concepts and specifically cross-referenced the section of our bankruptcy code that has an automatic stay and uses the same one, which is broader than what's provided in the model law. How so? The automatic stay that is available under the US Bankruptcy Code, it's section 362, for those of you who are following along at home, it stays all actions that could have been brought before, that accrued before the petition for bankruptcy, right? So it stays all pre-petition claims against the debtor and basically channels those into the bankruptcy process rather than proceeding in different courts. And I know that's very different than the Brazilian system, right? In the Brazilian system, the claims still get liquidated outside of bankruptcy, and then they're brought and registered through the proof of claim process in the Brazilian case. But that's not the way it is in the US at all. The litigation that's ongoing against a debtor in order to liquidate those claims should be brought into the bankruptcy proceeding rather than, so they're stayed if they're happening outside. Also, you know, any actions to obtain possession or to create a new lien on the property of the estate, even if, you know, the creditor should have created a lien earlier because he had a right to create a lien, but if he didn't actually create the lien, he no longer has a right to after the bankruptcy after the bankruptcy begins. So all of those actions are stayed under the US process. And to pick up what Sheila was talking about secured creditors, right? So in the United States, we don't quite have the same rule, but there is a provision that allows someone to seek relief from stay, and it is often used by secured creditors, but it's not enough for them just to say, I'm a secured creditor, so I automatically get relief from the automatic stay. They have to show good cause for the relief, and usually that is because there's no equity left for the estate. So their lien and the value of their claim really has to be enough to eat up the entire equity. And it's also taken into account whether or I guess an alternative is that they are not receiving adequate protection. So if the debtor is allowing the property to waste, or the debtor needs to pay them something in order for them not to be in a worse position than they otherwise would be, then they're often entitled to lift the stay or to receive relief from the automatic stay, and then they can proceed against that asset.
Thanks, Nayana. Sheila mentioned that the power to take evidence concerning the debtor. This is an area that the model law includes general provision making it possible, but it's looking very different in practice from one country to another. So let's talk a moment about how this relief is implemented in each jurisdiction. Sheila, how is the evidence gathering in a cross-border case in Singapore? And then if Nayana wants to say something about US and Isabel, although we haven't seen it in practice, if you could clarify to us some point, because we have just 10 minutes, I think so.
Thanks very much, Paula. I'll make it quick. Yeah, I'll make it quick so that the rest of the panel also has some time to chip in on this. And before I start, I do realize that we're running out of time, so I would also like to thank everyone, to thank Liv, and Paula, for organizing this, and Fernandez as well, and the rest of my panelists. And it's very good to see Isabel again. Even though it's virtual, hopefully we'll be able to see each other in person at the next Insol conference. In terms of evidence that's being gathered, I mentioned it very briefly earlier. There is a power to compel. So basically, in terms of the, cooperation, seeking cooperation from the various individuals, office holders who have information about the company or property about the company to come forward. But if they are not forthcoming, with that, an application can be made to court to compel, and that's where all that the foreign representative, or in Singapore, if it's an insolvency practitioner in Singapore, they have to do is just simply make an application to court and setting out why it is that the information is necessary, why do they do not have it in the first place, and they believe that particular individual or company has the information, and to get the information from them. So the court has the power to compel, and also to summon any individual to court to give evidence, on the stand, basically to give testimony. In addition to that, there's of course also outside of the insolvency regime, the ability to, seek disclosure orders. So even if, for example, there isn't, any set of proceedings here in Singapore, there's always the ability to apply for disclosure orders. And these disclosure orders will be basically to find out information or find out causes of action, to plug a gap in terms of evidence finding, to identify whether I have a good cause of action against a certain individual, or to piece together the puzzle to be able to go and trace monies into a different country. In fact, what a lot of times that we do here is to take out bankers' trust orders, as we call it, and these are disclosure orders being sought against banks for information in relation to the monies that have been deposited to one account and then moved on to another, and we just try to trace when we try to trace the monies and try to recover. So in brief, the court does have quite a lot of power in compelling evidence to be gathered. So onto the rest.
Sure. Well, I will be very brief on the US part of gathering evidence. It's fairly similar to what Sheila described. I think the key for the Brazilian audience is to understand how the process starts here. We have a very broad rule. Again, it's an outside of model law rule that gets brought in by our judges and by judicial interpretation. So in our general bankruptcy cases, we have Rule 2004. It allows very broad discovery into all rights, assets, obligations, etc., anything of the debtor and affecting the administration of the estate. So that rule is not expressly in the model law, but because it's in our general bankruptcy rules, it's been applied in our cross-border cases under Chapter 15. And what triggers the application of that rule is the issuance of what we call a subpoena or a notice of examination, simply a notice to the debtor or to another person. It could be a notice to a third party that you need them to produce evidence or to produce testimony. So that notice, unlike in Brazil where it has to be issued by a judge, in most districts in the United States, we now have rules allowing attorneys to issue them. So the process gets started fairly quickly and efficiently. The attorney can draw up the subpoena or the notice and issue it directly. And then, as Sheila was describing, if there's a dispute over it, then that goes to the court, right? The person who's responding to our subpoena can instead of providing the evidence requested, they could provide objections. They could say, you're asking for things that you're not entitled to. This has nothing to do with the debtor. And then they have to provide support for their arguments about why they shouldn't produce the evidence. And once those arguments on both sides are fully fleshed out, then it goes before the court and the judge decides whether the evidence must be produced or not.
Thanks, Nayana. Isabel, do you want to share something with us about the Brazil?
Yes, even though we don't have case law on that, I think it would work as we see today when a debtor or a creditor seek a relief in a domestic insolvency proceedings. I think it's important to distinguish the situation where we have the foreign med application for recognition in Brazil, the law, the UNCITRAL Model Law, and we incorporated the same idea, will allow the judge and its discretionary to provide reliefs to protect the interests of these creditors even before a decision is granted upon application. Then when a decision of recognition is granted, the judge still holds the power to protect the assets of the debtors or interests of the creditors. And then when we have the recognition of a main proceedings in Brazil, then the law provides several reliefs that the court will grant automatically. And I think it's pretty much aligned with the reliefs that, injunctions and reliefs that we see when the judge, when a court in Brazil applies the Code of Civil Procedure to insolvency proceedings. So we don't have discovery in Brazil, for example, but we have measures such as our ação de produção antecipada de provas, our claim, and we have a very expedited procedure in Brazil today that allow a claimant to require documents and information against a defendant, and the court may apply penalties, and it's a very expedited procedure. This is one of the things that I think we can foresee that could happen in the context of insolvency, cross-border insolvency proceedings in Brazil in order to collect information such as trace of assets, for example. And it can be preparatory to another measure in Brazil, or it can be an autonomous claim against from the creditors against the debtor in Brazil. I think it works pretty much the same. The claimant must prove the relevance of the claim to protect its rights and interests, and the defendant will be summoned to furnish the court and the claimant with documents and pieces of information relevant to the case. We have very specific and particular tool available to courts in Brazil, which is our CISBA de Massanjud. It's a very, let's say, effective measure to attach assets of a debtor under certain circumstances when the claimant evidenced to the court the need to protect these assets from fraud or from being sold by the debtor. So there is a risk or a threat over an asset, and a judge, the judge that has a kind of very efficient system that I like to compare with an Amazon one-click shop. Like that, the judge presses a button and the court will have full access to the deposits under the name of that debtor, and will immediately and automatically attach these assets and guarantee that any claim and value under dispute will have that amount available to the court to be available to the creditor to have in the end of the process to be reimbursed and collected this money. So it's a particular, I think, situation of Brazilian law, maybe different from other jurisdictions. And like, as we like to say, the claimant, the debtor will have like the assets attached, and then the creditor, the debtor, will have to respond to the claim and try to remove this constraint over its assets in this process. So very efficient. I'm lawyer mostly to investors and debtors, so I have a lot of caveats related to Basta Injúria and Cisbajúri, but I think it's important to note that it's a particular measure available by Brazilian law to creditors. If you want to use, it's available to you. But I think like this is what's going to happen under the cross-border insolvency proceedings that will require the court such reliefs to protect the interests of creditors that have claims in Brazil when there will be a collective claim. Probably, I think the Brazilian Code of Civil Procedure has a very broad range of reliefs, specific or not, and they will have access to it in the context of insolvency proceedings for sure.
Okay, thank you, Isabel. I think that we don't have time for questions from the audience, but feel free to send me any questions on my email at paula.silva@dfalaw.com. So
Paula, you're muted.
Paula, you muted.
sorry. No, but you heard about that we don't have time for the audience, the questions from the audience. So it's okay. Okay. So I would like to once again say thank you all the panelists, Sheila, Nayana, Leisa, Isabel, for taking part of this event with iWork. It was a pleasure to hear from you. I personally admire all of you for your practice, and I look forward to seeing you in future events. Thank you so much. And so I think that Fernanda.
Yes.
Are you there?
Bom, pessoal, muito obrigada pelo painel. Thank you, Sheila. Thank you, Leisa, Nayana, Isabel e Paula. Nós vamos fazer uma rápida pausa e nós já voltamos em instantes para o nosso segundo painel da manhã.
Thank you.
Everyone.
Bye-bye. Thank you.
All right, we're back. First and foremost, let me thank you all watching us this very morning. And let me talk about our second panel about insolvency under ICBC vision. It will be moderated by Irene Tsotsugu, CEO of Tsotsugu and Associates and member of IRIC Brazil, and we'll have the participation of Dr. Liv Machado, Inferis and Chair of IRIC Brazil, Juliana Biocchi, Main Director at Biocchi Empresarial, Judge Sage Sigler, that deals with the north of Georgia, and also Dr. Valesca Miguel Batista, Master in Sustainability. Irene, you have the floor. Good morning, everyone. It's a great honor to be here in this virtual panel with major specialists, people I admire so much. Judge Sage, it's an honor. Lívia Machado, Juliana Biocchi, Valesca Batista. Of course, I would also have to congratulate those who came before us, not only today, but throughout all these days of our conference. It's been a very enlightening moment of exchanging experiences with people of utmost caliber in a very simple and yet dealing with such complex manner, but being so easy to understand. And our theme is the insolvency of the individual under CVC's optics or vision. And remember that the law number 14181 of 2021, which alters the Consumers Code and establishes a series of new rules to deal with super debt. It's important to note that the National Confederation of Commerce raised some numbers in 2020 in which they found that the number of families in high debt for credit card, for instance, have gone over 66%. Ladies and gentlemen, the Brazilian debt is about overdraft. It's about car finance, credit cards, real estate. And this year, as it couldn't be any different in face of all the systemic crises being faced in this country, and of course also caused by COVID-19. In June this year, the sheer number of families in debt in Brazil has reached almost 70%. The law, which we'll be dealing with, that has just come to fruition in July, has added some major principles to substantiate and reinforce its own purpose. And the themes that will be properly presented by our panelists, I imagine that one of them is responsible credit principle. This is something that we've been fostering, the bare minimum existential and the protection for avoiding unnecessary luxury. And this goes over credit offer and preventing people from going into debt and for using the law in a proper manner. From everything that has been debated and being performed, we have sought to promote judicial balance between credit itself, the debtor, the charger. Of course, we need to take into account the powers at stake and the laws which we have at our disposal. In a very simplified context, understand that the consumer who is in high debt, featured by just the adding all their debts and diminishment of their income, we understand that we want their human capacity, their human responsibility, and their dignity to be kept. And this is something that will be addressed by our panelists, how to look for an attorney, how to rethink their debts, how to have a means to deal with said endeavor. That term is part of the Federal Constitution and the Consumer Defense Code, and perhaps it's one of the greatest spring loads to justify the law of high debt. And additionally, we'll be very satisfied to be able to deal with such issues in this panel. Without any further ado, our very dear Valesca Batista, which has honored us to be here in this event and will bring about the data of high debt. You have the floor, Valesca. Good morning. Good morning all. It is actually my pleasure to be here. Such an honor to be here with you at this very important event on this conference on insolvency, so that I can debate with you high debt. I'm glad to be here with you with such huge names, which empowered women who are high intellectuals on this very theme. So I thank you in advance. In terms of data, it is important. It's interesting. Do you read me well? Can you hear me well? Because I don't see many of you. Oh, okay. Thank you. Thank you for responding. Okay. In terms of data, it's interesting to take into account why has this legislation come about. When we're talking about high debt or super debt, which is a term in Portuguese, this law 185, which was presented by Irini, we're talking about the individual. We're not talking about a company. We're talking about the dignity of just one person, one individual. That's one social security number. So that hits an audience which has a profile. I mean, this is not something that people are thinking. This is not 10 million Brazilian reais or a million Brazilian reais. We're talking about numbers that on average, according to the default map, states that it's a profile of people talking about 3,900 Brazilian reais for total debt. So each debt is about, on average, 1,900 reais. So we're talking about small numbers. However, they are elevated when you have a sheer amount of the population being paid less than minimum wage. And that has a strong impact because we realize that in major crises, such as the one which we're living in Brazil currently, people end up being highly impacted, and thus a snowball effect happens. And because of the specific COVID crisis, because of the pandemic, a huge number of men and women were laid off from their jobs and are in a high vulnerability situation. These people were people that usually got up to three times the minimum wage. They were paid 3 times the minimum wage per month. And now they're not getting any money. No wonder the small debt is now going into a snowball effect. And these are people that are getting debt out of utility bills. This is not about somebody buying a Louis Vuitton bag. This is about sheer everyday consumption of somebody who was at a vulnerable position. Just everyday living, utility bills. Again, snowball effect. It's not about luxuries. It's not about splurging. And we can see that this has a direct effect when looking at data and realize that those people, in the majority of them, are women. The number of default people for August, we're talking about 50.3% of them are women who defaulted on their payments. And the number of layoffs during the pandemic hit harder on women. And when we're talking about racial profiling, which is also part of economics research, when we're considering economics and racism and gender inequality, we also notice that Black and brown women have also been impacted by this super debt scenario. The default map, and this is something interesting to watch, it does not take into account the racial inequality. So it does profile gender, but not race. And it's interesting to think about that when we're analyzing the mechanisms of the law, which we're going to encompass here and address here. If you're taking into account refinance possibilities for consumers to check their debts, what is available by law? You know, what can you pay for those who charge you? You will see race-wise that Black and brown people are at their most vulnerable. And also because that's also the same group who has been laid off the most. So it is something that was already prevalent in our society that has now aggravated. So now we have the women profile, and we have no idea about the race of those women. So, but I can assure you, it's about Black and brown women, and then Black and brown men, and then we move on to a different profile. And we're talking about young people. Let me check the numbers here for you so I can give you not a ballpark, but an actual number. Okay, the average age of those who have been mapped who default their payments for August 2021, it says that 35.6% out of that group represents an average of 30% of the Brazilian population. That is a huge number. Their debt from this data shows that 30.6% of them are people aged 26 to 40. So that is the average age, people who are already active, you know, working class people. Now you have a second group is 41 to 60. So that's 35.2% out of that group of people who have default on their payments. And then you have people who are over 60 that has an average of 17.3% out of that group. And up to 25 years of age, that's 12%. So you can see that the bulk of it is 26 to 40 years, that people who are already working people, people who have degrees, but who are also laid off, massive layoffs. And that's when we think we need to analyze this from a global perspective, even to start asking questions or thinking how to deal with super debt, with that high debt. What about financial education? That needs to be taken into account. What type of financial education do people get in Brazil? The bare minimum always addresses this. Then this is written on the Constitution, a fundamental right, health, safety, as well as a healthy financial life, because that impacts every sphere. And if we look straight into each debt number, we can see that they are above minimum wage. Let me remind our English speakers that minimum wage in Brazil is through salaries per month, not per hour, okay? Just to give you a better picture. So what we can also observe on that map is that an average Brazilian, about 30, a little over 30%, if we're thinking about that age range, up to July 2021, those people, according to the Consumers Default Survey, Brazilian families were at 71.4% some form of debt that were default for 30 days, and then they would honor it. So those numbers are also considered. So people being late on their payments. So what do all those numbers show? It shows that because of the crisis, we see that there was an increase in the credit possibility. How often do we get a message that says, oh, you have a new credit limit to purchase this at a grocery store or at a supermarket, or if you have an urgent matter, we will provide you with credit. And this is the entry point for going into debt for those families. And there's what we call these people, it's a jargon, we call these people of good faith, people who are good for their money, good for their payments. But what we have here is a systemic issue. Why do I use the word systemic? Because this is a reflex of racial inequality and gender inequality. This is a panel for women, and we are indeed a vulnerable group because it is harder for us to be part of the market. And naturally, it will be harder for that person to obtain money. It will be harder for that person to consume, and so on and so forth. And what we're talking about here is a sheer mass of women facing this salary, this wage inequality. So if you're getting paid to consume something, but the consumption of said product is becoming more and more expensive because of inflation, naturally, that will affect you directly. So that's the data. Serasa, the Brazilian agency for numbers, has shown that August 2021, a total of those debts, 62.5, excuse me, that's wrong. For the total Brazilians in debt were at 65 million. So that's over 30% of the Brazilian population. And that impact is still caused by people who are still consuming goods. Now, people who are under the poverty line, those people will not even be able to have those debts. So we have a specific rate for people who actually have access to that, to even become a number there. And let's see what are the mechanisms that these laws will offer. Remember the term I use, good faith. Otherwise, there will be no means for that person to renegotiate the other debts. So fail to comply with that will have a direct impact, and we will hear about that from other panelists. So to be able to teach financial education is something that will require an effective public policy that caters to, or that addresses all these economic issues, fee issues, tax issues that have a huge impact in the lives of women, of Blacks and Browns, and society as a whole. Because the super debt, this high debt, naturally has a financial impact that makes you rethink public policies. Remember, this is not private, this is also about public order. So without any further ado, I'll be glad to answer your questions later on. Thank you.
Valesca, that was an excellent approach. I'm really very happy to be able to participate in a panel with the numbers in such a light manner, numbers of a systemic problem that we have, and that makes us reflect about the numbers on how much they are frightening, right? To suppose that a huge number of families are in a vulnerable condition without the minimum to maintain human dignity, to pay for this minimum in the cyclic indebtedness system without any possibility to see a light at the end of a tunnel. This is truly concerning and frightening. And furthermore, from what you said, we realize, and it makes us also think that with the unemployment which affects us above all in this post-crisis moment, through the amount of default cases we're seeing, many times people don't find jobs to restart, to deal, to return, to be able to start back again. And I really feel very happy for being here to be able to live this moment, to learn with each and every one of you. We're still going to learn a lot more. This is an essential debate. This is an essential project. And I'd like to call now to the debates Dr. Liv Machado, who will give us an overview on this super indebtedness in Brazil. And Dr. Liv, the floor is yours. Good morning. And I would like to add to what my fellow panelists have said, Aline, Juliana, Valesca, thank you very much, Judge Sigler, for joining us this morning. And I believe that after this very important approach, I think sometimes we are very much in legalese and we forget to look at the reality, because the law is here to serve us, to serve our reality. So I think it's very important for us to start with this data that Valesca has presented to us in a very cool manner. And already to look at this, I'm going to allow you to, I don't know, let's say, give you a description of what the law is like, because our law is very recent. It still depends on the rules regarding the more in-depth concepts. So I think we're still a bit lost in interpreting some of these concepts. And it will be very important for us to be able to talk a little bit about these changes, which the civil procedural law has, and also to see the US experience, the experience from the United States with bankruptcy of individuals and of legal entities, which is not exactly what the superindebtedness law has, but this is an instrument which is slightly closer to what already happens in the United States. So going on to some concepts which the law brings us, it has a lot of what has been mentioned, the minimal to exist. This is something which shows the superindebtedness in terms of being able to pay debts by a consumer, but without them involving this minimum amount. So there's no point of having a payment plans or program to pay if at the end they won't be able to maintain themselves to pay their bills. And the main objective of this law is exactly to be able to fight the social inequities, especially caused by the economic crisis and the pandemic, as has very well been mentioned by Valesca, who spoke just before me. And I think it's important to mention, and this is something that Ju will be able to tell us more about, is that this law ends up being applicable with a change to the individual in terms of access to credit in a situation of superindebtedness. In other words, it leaves out the individual who will become super indebted because of a debt of a different profile, which isn't a consumer debt included in the consumer protection law. And on the other hand, this is applicable to all suppliers that have credits to receive. And this is something that are the financial issues. And this is something which is being affected by these new guidelines for the supply of credit, which are changes presented to us by the Consumer Protection Code. So one of these changes is that this credit protection has to be done in a responsible manner with validity. They have to assess the consumer's possibility of complying with those payments, and they have to take into account the default risks. Therefore, it is mandatory for those who are supplying the credit, and the supply must tell you the total cost of that loan, the interest rates and other fees. Sometimes it's very difficult for people to truly understand what they are becoming involved in, and also the total amount of the monthly installments, and obviously all other issues which might be included in terms of central bank rules. This original project also sees some changes that we have today, and this is something which has been stopped when we talk about the presidential sanctions. So this is something which was not included here in this change in the law. And here, it is important for us to think about what changes in what we're talking about, changing the credit in these changes which are being presented. The law tells us that the vendor will not be able to charge any amount which is being challenged. And this is with a credit card or something similar. So if it says that when there's fraud in this credit card, they will not be able to make it difficult to cancel the sale or to return the amounts which have been charged from the consumer. So they bring us these new rules regarding in terms of charging for the credit. And there's also a very important change, which I think we can look at in a more in-depth manner. the issue of renegotiation of debts and of credits, because the law brings a new system. So it is very likely that this consumer may negotiate these debts both outside of the courts as well as through the courts. So the law makes it optional for the state consumer protection boards and also all the consumer protection boards in cities and state levels to fight indebtedness, as well as what Valesca has mentioned, which are aspects which are very important in terms of financial education. And apart from the administrative system, the consumer may also request a renegotiation through the courts. And using the courts is a procedure which will have a agreement meeting with the creditors and to possibly establish a payment plan and also a plan which is mandatory for those payments. So talking about the changes in the consumer protection law, any of the debts can be renegotiated in the new form to renegotiate the debts? No, that's not the case. It's important to make this very clear. You will not be able to renegotiate debts that, for example, are done with bad faith. Obviously, this is subjective, so it's not very easy to prove in practice, or debts which were taken on without that were never intended to be paid from the start. So very high amounts and credits with secured credits are also not included. So if a consumer has given a form of a security, they will not be able to include that debt in the renegotiation process. Also, debts regarding funding real estate is not included, and also those which are related to rural credits. And it's important to remember that the legislator doesn't have a minimum or a maximum amount for the debts which can be renegotiated. They have publicly established that this is something which might be taken into account in the next few months. So this is still something which is pending on those details, which the law has not taken into account. And the renegotiation request can be done at any time. Can it be done at any time? So especially the consumers are in this situation of super indebtedness, if they've made an initial request for renegotiation, they will only be able to make a new request 2 years later after paying all the debts included in that first negotiation. So in the first payment plan, which they have agreed to. And the conditions in this payment plan, they may not adopt measures which worsen even more the situation of super indebtedness. In other words, the consumer makes a payment plan, and if they adopt any measure which will worsen even more, at the end of the day, this is something which doesn't work. So it ends up not working its purpose, which is the idea behind this law. I'm not going to go too much into the issue of the negotiation through non-judicial forms. I'm going to be concentrating a little bit more in this legal aspects, but what the law foresees is that when a consumer petitions this renegotiation procedure, the judge will schedule a meeting to try to find an agreement, and they will call the creditors. During that hearing, the debtor can present a payment terms. It's up to 5 years established by the law, so it cannot go beyond 5 years. And the creditors will then be able to set up an agreement to pay for the debt. And it's very interesting to make a comment here and to show a parallel of this is something that we're more used to, because our law doesn't establish a term, a maximum term for the payments. And something else which is interesting, and this is something which is what the consumer will be able to make different negotiations with their creditors. And there's no case in terms of the reorganization, the different classes of creditors, the creditors with guarantees, creditors with a security, etc. So those are the cases that you have the creditors that are banks, and banks have a different type of treatment. Others that you don't have subclasses, etc. So this is something which are different areas where the consumer will do the payment plans in a different manner regarding each one of those banks. This is something that we are looking at a specific type of creditor. And for us to see this law that we have for reorganization. And something else which must be included is the measures which will be adopted by the creditor. And this is something when we talk about the terms that they have for payments, or a smaller amount of a debt, etc. This is all something that will be an object of this payment plan, the date in which it will be published, of the consumers that will be removed from those registries of negative credit, right? Bad credit registries. Because if their name is in one of those bad credit bureaus, even on a daily basis, not necessarily to take a new loan, but it's something which is very important. And this is also something which would make a reference to, this is something which is ongoing, an exception of payments, etc., consumers. This is something that must be the result of a specific plan and a commitment for the consumer to not practice measures which might worsen their situation of super indebtedness. And something very interesting is that the creditor appearing in this initial hearing, is it mandatory? The law doesn't say it is mandatory, but on the other hand, if a creditor does not come and does not present any justification for not attending, the likelihood of charging that credit is that it has a stay. So the interest rates are stopped, and at the end of the payment, the debt will be under the mandatory plan if that is established. In principle, the idea is that those are the negotiations, individual negotiations with those creditors which are taking place in these agreements. And we will then be in the possibility of a mandatory plan to be set forth by the judge. This is another important, which is difference in our bankruptcy law for individuals and companies. And all creditors, should they agree that there's that hearing? No. And the creditors don't have to mandatorily accept it. So in a reorganization plan, when you have the majority of a minority approving, the minority ends up being pulled on and has to accept the general conditions proposed by the debtor. And in the super indebtedness case, that's not the case. So, for example, if that creditor doesn't understand, if they do not agree with what is being suggested, if they think it's not interesting, they can just simply not agree, and they won't be, it won't be binding based on the desire of the majority. And if there's a situation in which the creditor doesn't come to an agreement, they will also have to present an answer in this regard. And once this situation, when you say, oh, we haven't been able to come to an agreement, the consumer will be able to ask the judge to set a mandatory term for the payments of the debts which were not included in that agreement. And it's interesting because this is something which doesn't drive the creditor to just let it roll, let's say, without reaching a negotiation. Because what the law says is that the judge can review the clauses in the contract. So when we get to mandatory plan, that's no longer a negotiation between the parties. So for example, a judge can determine that a specific interest rate is abusive. They can review fees that are included inside the contractual clauses. And on the other hand, it's also very important to take into account that this mandatory plan should maintain the full amount of a debt with the interest rates. This is a difference that we have in our reorganization plan because there's no mandatory plan in terms of reorganization, but there's a freedom to foresee a loss in the premium, let's say, what is going to be the type of interest rate. So in this mandatory plan, this is already predetermined by the law. The parties are not free to negotiate this. And as I've mentioned, the maximum term is 5 years. and the first installment has to be paid in up to 180 days. So for example, you won't be able to go beyond the 180-day limit for the first installment. Regarding how this affects, how the issue of a renegotiation affects these issues, procedures, legal cases, etc. If a creditor doesn't come to a hearing, their credit is then has a stay. And in terms of a hearing, those aspects must be addressed in this first payment plan in terms of how their credit history is assessed. And in the case of a mandatory case, the law is silent in that matter. So in other words, if the ongoing cases are stayed or if they are canceled, so this mandatory plan is something which ends up not being very interesting for the debtor themselves, because they won't be able to have access to that if a creditor with good faith or out of free will doesn't agree, doesn't allow these cases which are ongoing to be made null. And therefore, that will follow its regular right until they are paid for, or in other words, at the end of the 5 years, if a consumer is able to make the payments of those amounts. And just to wrap up these comments that are being discussed here of what was changed by the law. So we have some issues pending for them to be regulated. So in what way will the consumer be able to require this liquidation? The law doesn't say, for example, what is the judge which has jurisdiction, or is it going to be a low claim courts or not, or this practice of the agreement hearing in terms of debts of consumers. For example, in Porto Alegre, in the south of Brazil, they already do this for many, many years. The law is also not very clear that if that hearing to find an agreement is not fruitful, how will the consumer start the procedures for superindebtedness? How will they ask for the mandatory plan to be established? So those details are not in the law. And even if you need to have an attorney present during the renegotiation, it seems that it might be necessary because there's a hearing taking place, but the law doesn't establish that. Are there any requirements for this process to be open at a minimum or maximum amount, as I mentioned, a percentage of creditors involved? The law doesn't set that forward. And this issue of when this right to charge back is no longer enforced. So the law doesn't say that. There's no statute of limitations, let's say, in terms of this debt when we're talking about regulating these issues in the future. So I believe those were the comments I had on the change of the law so far. Thank you very much.
Thank you, Dr. Liv. That was a very nice approach on this new systematics. The types of debts that can be renegotiated by this new procedure. It's a new system that we have in place among us, and quite recent at that. And without a shadow of a doubt, the law of the superindebtedness, or the law for the judicial recovery of the individual, since we are working on that topic, it's something that is going to be quite positive for us. For credit card, department stores, that they've been providing that on the market. What about customer awareness in terms of responsible credit? Let me address that since we've been debating that so much. Well, it's about becoming a law that's been coming through our federal constitution. Ladies and gentlemen, among everything that we have witnessed during this very rich panel, chock full of information, our constitution is crystal clear in terms of dignity and the treatment of the individual with said dignity, especially on the theme that's being approached here, the respect of the consumer on human dignity and the bare minimum for existence. In Portuguese, mínimo existencial. So what we're witnessing is that we're actually starting a new stage of the applicability of the consumer code. And if I'm not mistaken, it's now 31 years old from its inception. I believe that it is worth mentioning from your speech, which was a very assertive one, which was very well thought out, that the superindebtedness law also foresees the management of the issue by the public powers that be. And many people are unaware of that. They're unaware of the agencies that are there to provide them their defense, the idea of rethinking their debts and how to deal with them. Furthermore, along those lines, which were also encompassed or mentioned by Dr. Liv, this is not about civil insolubility. It's not about, so the consumer owes more than their own assets. It's not about that. It just means that this person retains their purchasing power. And I believe that we are going through a new paradigm of a very clear changing system. Liv, we have a question on YouTube chat. So I don't know if we have maybe Dr. Valesca or Dr. Liv would like to address that. It's from Dr. Juliana Sato, who is one of the directors of our WIC. Fantastic professional individual. Thank you for your question. She says, I'm not sure if you're going to address this later on today. In such extrajudicial cases, should consumers go for PROCON, which is the consumer agency, consumer protection agency in Brazil? Well, I don't know if this will be addressed on the next panels or if Liv or Valesca can answer that. Liv, your microphone is off. Oh, okay. Dr. Liv, please. Dr. Liv. No, my apologies. Well, the law states that it is optional for the consumer defense agencies such as PROCON, be it state circle, be it municipal circle. Well, these are the agencies that the law establishes as the responsible agencies for court supervisory organization. The law doesn't go into detail about that, so I truly believe it depends and to go into the fine print, but I'd say that these are indeed the agencies who are responsible for those matters, okay? So without any further ado, we are honored to have Judge Sage Sigler, who will tell us about bankruptcy of the individual in the US and then, of course, compare it to the Brazilian market. The floor is yours.
Good morning. Thank you so much for having me here and inviting me to join your panel. I am honored to be here this morning. I am a little regretful that it has to be virtual. I had the honor of coming to Brazil to join an iWork panel in the summer of 2019. And I still tell people I don't think I have ever experienced hospitality the way that I did when I was visiting. And I do hope to come back again soon. So I will talk a little bit about the consumer bankruptcy process in the US generally. The US has a long history of consumer bankruptcy that the modern system was really based on an act enacted in 1978 that eventually became the Bankruptcy Code in 1984. And the most recent major overhaul of the US Bankruptcy Code was in 2015. Of course, we do have changes that occur regularly, but that was the last major overhaul. So consumer bankruptcy or individuals in the US can actually file for bankruptcy under any of our 3 chapters. Chapter 7 is liquidation. Chapter 13 is reorganization of consumer debt. And Chapter 11, which is typically what people think of as being for corporations, very high net worth individuals can also reorganize under Chapter 11. Chapter 7 is essentially when a debtor sort of throws their hands up in the air and says they're not able to pay any of their debts. There's a trustee appointed who collects and liquidates any assets that the debtor has and distributes those evenly to the debtor's creditors. Chapter 13 is more similar to what we were all here talking about this morning and Brazil's new reorganization process. The main difference, though, really, is that Chapter 13 in the United States is primarily used by consumers to save their home or their vehicle. So for secured debt, which is expressly excluded from the Brazilian law. But at a high level, the way it works is, and some of it depends on the amount of a debtor's income. If a debtor has below a certain threshold of income, they can file for Chapter 7. But if their income exceeds that level, they're required to file for Chapter 13 in an effort to repay some of their creditors over a period of time. And so that could happen and does happen, even if someone is not trying to reorganize the debt around their home or their car. Chapter 13 plans must last a minimum of 36 months and typically a maximum of 60 months, although there is some temporary legislation related to COVID and the pandemic that allows parties to extend that period out to 72 months, but typically it's 5 years. And in the US, they're all considered judicial proceedings, even though much of what happens is consensual. So the debtor files a petition seeking bankruptcy relief from the bankruptcy court. So they are commencing a court proceeding to do that. There is a meeting of creditors where creditors are able to come and ask the debtor questions. And the debtor then proposes their plan that is how they are going to go about repaying creditors over time. A couple of points. So for unsecured creditors, credit cards, medical debt, which I'll mention medical debt in a minute, but credit cards, medical debt, any unsecured debt, the debtor generally has to repay all of those creditors in the same fashion. So if the debtor, and Chapter 13 plans can range depending on the debtor's income and assets, the debtor can be required to pay anywhere from 0% of that debt back to 100% of that debt back. So if the debtor is proposing to pay, let's say 30% of the debt back over time, all of the unsecured creditors are going to receive 30%. The debtor is not able to negotiate one deal with one creditor that may be more favorable than what they're going to repay another creditor. That's not necessarily true with secured claims. With secured claims on the house and the car, the debtors have a little bit more of an ability to negotiate directly with those creditors about interest rates and things of that nature. But that does remind me to mention, Waleska mentioned early in the panel that super indebtedness was not about splurging. And that is also true in the US. Most of the debtors that we see file for bankruptcy, perhaps they've not made the best financial decisions, but for the most part, it's triggered by some sort of job loss or an illness, because in the US, we don't have any sort of universal healthcare system. So we see a lot of people come in, if someone has had cancer or something like that, that has required a lot of medical treatments, that in itself can push somebody into bankruptcy in the United States. But those debts are dischargeable through a bankruptcy process. Similarly, people in the US don't always understand what debt they're taking on, what the interest rate is, what the payments are going to be. Unfortunately, even though the amendments to the bankruptcy code in 2015 sort of sought to help provide some sort of consumer education. And so the code does require that every single debtor has to participate in pre-bankruptcy credit counseling, is what they call it, before they're allowed to file the bankruptcy case. And if they're in a Chapter 13, they also have to participate in a financial management course before they can receive their discharge at the end of their case. Unfortunately, we're now, 6 years down the road after the amendments, and it does not really appear that those credit counseling classes are particularly useful. I'm not sure. I don't know who it is that came up with what the substance of those classes had to be according to Congress, but I don't think they really teach debtors budgeting and financial literacy in a very meaningful way. So if that is something that your legislators are working on, hopefully they can come up with a better solution. So Chapter 13 plans, like I said, and I can give you just some numbers to get an idea of how frequent this happens in the US. And I'll give you the 2019 numbers first, because our bankruptcy numbers are actually really down. Bankruptcy filings have decreased a lot during the pandemic. Our best guess is that is because there have been really significant federal unemployment supplements in the US that only just ended. In some states, they ended in July, and then in other states, they've just ended, in the past few weeks. And because of that, there are a lot of people in the US who were actually bringing in more income on unemployment during the pandemic than they were when they were working full time. So that's one piece of why bankruptcy filings are really down. The other is that there have been eviction and foreclosure moratoriums that have prevented banks and landlords from kicking people out of their homes, which is a big reason that people file for bankruptcy. Again, because here in a Chapter 13, that stops the bank from foreclosing and allows you to try to keep your house. So in 2020, we only had nationwide, we had almost 153,000 Chapter 13 filings, but that's a 46% decrease from 2019, when we had almost 283,000 Chapter 13 filings. So we have a lot of Chapter 13 filings. Having said that, one of the reasons that those numbers are so high is that not all plans are successful, and really more Chapter 13 cases fail than succeed. So again, these are 2019 numbers. In 2019, 57% of Chapter 13 cases in the US were dismissed without the debtor completing the plan and receiving their discharge, whereas 43% of the plans were completed and the debtor received a discharge. And again, the reason for that, most of these, even though it's a 36 to 60-month time commitment, most plans do require a 60-month time commitment. The debtor needs those monthly payments to be low enough, and so it takes them that longer period of time to repay the debt. And a lot happens in a debtor's life over a period of 5 years. You really do have to be gainfully employed and bringing in regular income to be in a Chapter 13 case and to have a plan confirmed. And over a 5-year period, you could have another job loss, you could have another major illness. And so oftentimes we see debtors, Chapter 13 plans fail because another life event has happened. Now, some of those cases do convert to Chapter 7 and become a liquidation proceeding. But a lot of them just get dismissed. And then the debtor, when the debtor finds a new job, they file another bankruptcy case. And so we'll see repeat filers who have filed multiple times over a period of years trying to accomplish the same goals. Just looking at my notes to make sure to respond to some of the points that have been made. I mean, that Chapter 13 is a very complicated statute in the US, and one that requires not just an attorney, but really an attorney who specializes in Chapter 13 to do a really good job of proposing a successful plan and getting that plan confirmed. And, that attorney is representing that debtor over the entire 5-year period. So helping the debtor get through whatever questions or issues pop up over that period of 5 years. We do have debtors who file for bankruptcy, what we call pro se, without an attorney. Occasionally, a debtor can get a Chapter 13 plan confirmed without an attorney, but it's very, very difficult. The difficulty with all that is that it can be very expensive for a debtor to file for Chapter 13 because it is a complicated process, and because really an attorney is needed for that process to be successful. A Chapter 13 case can cost a debtor the attorney's fees. There's a filing fee for the court. That's not, I mean, it's, I think it's just under $400 now. But the attorney's fees for a Chapter 13 case, it depends on where you are in the United States. But where I am in Atlanta, Georgia, the attorney's fees can be $4,000, $4,000 US dollars, $5,000 US dollars. One benefit of a 13 is that the debtor can pay those attorney's fees over time. So the debtor can go to the attorney's office with no money in hand. Maybe the attorney makes them advance the filing fee for the bankruptcy court, but no attorney's fees are due up front. And the attorney's fees are just paid along with the monthly payment through the plan. Whereas in a Chapter 7 proceeding, the debtor has to pay all of those attorney's fees up front. Some courts and attorneys have come up with some creative exceptions to that. But generally speaking, Chapter 7, the attorney's fees are going to be a little lower, maybe $2,000, $3,000, but the debtor has to have those funds up front, which how many debtors have $3,000 extra dollars laying around? And so one thing that we do see in the US is that sometimes we have people file for Chapter 13 when really it appears that they could have filed for Chapter 7. And the reason for that potentially is because they didn't have money to pay attorney's fees up front. So that is something, how debtors are going to pay for lawyers to help them in these proceedings, and what the structure of the allowed attorney-client engagement is definitely something to keep in mind, because that can, even though it's not the intention of the legislature, those considerations can drive how and when people file for bankruptcy and how successful those cases are. One other point that was brought up earlier in terms of borrowers in the Brazilian proceedings sort of agreeing that they're not going to make their financial situation worse, they're not going to take on more debt. In the US, in a Chapter 7 case, because that's not a repayment plan, it's just a liquidation, anything that happens post-petition is really outside of the purview of the bankruptcy court. If the debtor goes and gets a great job making a lot of money, the creditors don't get to take advantage of that income. But likewise, the bankruptcy court doesn't have control over whether that debtor is taking on more debt in the future. In a Chapter 13, on the other hand, during the entire pendency of the Chapter 13 case, so for that entire 5 years, the debtor is not allowed to incur any more debt without express approval of the bankruptcy court. So they are not allowed to use credit cards. The trustee actually collects their credit cards at the meeting of creditors. So no use of credit cards. And if the debtor needs to refinance their house, buy a house, buy a new car because they've been in a car accident and totaled their car, they have to seek bankruptcy court approval to do that. So I think those were, I believe I've responded to all of the points that popped up that just sort of jumped out at me, but I'm happy to respond to any questions that the panelists or anyone else has about how our system works or how we address some of the questions that you all may be having about how your process is going to work.
Doutora Sage, estamos muito felizes e honrados com sua
Dr.
presença.
Sage, your presence is such an honor to us. Congratulations on being so straightforward, but at the same time, with a lot of sensitivity on dealing with the theme. Trust us when I tell you, you're always welcome in our country, always welcome in our country. And trust me when I tell you that we will eventually be talking about all these topics and the conference that's being held here today. If in Brazil, this is something not popular, in the United States is so popular that that brings about reflections and ponderings from so many scholars in the area. But both in the what's been exposed by Dr. Liv in terms of the Brazilian scenario, as well as what you have shown us in terms of the US, it seems that regardless of the standpoint, this is not medicine for everybody. There's the issue of going into depth. There are different profiles so that it can be further elaborated upon and put into action. For everything that was exposed here, it seems clear that there's a need indeed to compare both countries. This transversality between agencies so that we can better exchange these ideas and think of the best practices, the best international practices, and understand that our study is a newborn. It's not even a toddler. It's just being born. And we're quite happy to see that so many minds are working hard, debating and thinking about improvement. Without any further ado, and just as it happened in the United States with public agencies, when you're creating educative materials to raise awareness for US citizens to understand and take action or not go into action for Chapter 13 or 7, I believe that it would be interesting for us in Brazil to go also after that raising of awareness for the Brazilian population. There's it's such a long ways to go. And to deal with those gaps that are part of our law in terms of how can we improve, what can we do better, what can we create that's better out of everything that's being presented to us here today, the floor is now to Dr. Juliana Biolchi, who honors us being here today. Thank you. Do you hear me well? Hello. Congratulations for the initiative. The panels were awesome. And wrapping this up, this theme, it's very interesting to see this law that has now come to fruition. And to hear Judge Sigler to talk about this story and all those practices and a plethora of possibilities, so many instruments for people to actually put their lives back on track, that makes us at least have some expectation to have the Brazilian system to mature and have this myriad of possibilities. And that's why I think this panel is so important, you know. So once again, thanks for the invitation. I say hello to all my colleagues here, Judge Sigler, Valeska, Irini, Liv, and everybody who's watching us. And from my understanding, we need to debate because we had nothing in terms of reorganization, you know, renegotiation. There are things, there are some matters that were left out that need to be addressed and discussed so that they can eventually become part of the law and bring about opportunities and options for the individual. So there's a big gap in terms of the vehicles for negotiations of non-company indebtedness. So we need to reorganize the steps that have led us here. From Law 7661, it adopted the concept of the seller aligned with our commercial code. When the law 11,110 became in fact a law, it became a central element that a company for ourselves already represented a major step and put us in a more adequate compass to the Brazilian economic reality as well as the civil code that was reestablished in 2002. So that whole idea, the concept of company. Now, once you had a project of law that took place in 1993, it was discussed at that moment. So I'm talking maybe early 2000s, the possibilities for us to breach those borders. And it was clearly discussed the idea of us having a legislation that would encompass every type of crisis situation. And that would be the mission granted to Law 11,101. But there were so many battles to be fought that those battles, the sheer broadness of it, it was left aside in lieu of other things, meaning we did not have a mature enough discussion for that movement of broadening the system as a whole to be something possible. So at that moment in 2005, what did end up happening? For those who are artists, the scientists, who did not really have that company, LLC and the like element into their money-making process, they had no protection. So how would these people deal with that? Well, unless you're liquidating, you have no issue, you know, when you're trying to liquidate your financial obligations. So we have no instrument to deal with that. And we have no Chapter 13. We have no Chapter 7 in Brazil that allow us to say, here is how you do the math. From this point onwards, this is what you can do. This is the strategy you can draw. And this is how you're going to solve your financial issues. What we have is a legislation that is still ongoing. I think it was 1953. That is a process that is much more similar to bankruptcy than court supervised reorganization. So apples and oranges, you know? So we have no means of renegotiating that. So the law that changes the consumer code, which is a recent one, does fill that gap. Valeska mentioned data of real life data, life as it is, millions and millions of people that have those issues in Brazil, especially when they're credit related. Remember that in Brazil, credit offer is huge. However, interest rates and installments are among the highest in the planet. So you can imagine what happens after that. So people were vulnerable, you know, contract-wise, which was acknowledged in the law, but they did not have legal acknowledgement of that economic vulnerability. So when you're signing a contract, when you're incurring those obligations, the code will then come and balance those relationships. But at the moment the person is in debt, we had no legal benefit that allows for that person to rebalance their lives. So like Liv mentioned, this is bipolar, right? Because you're talking about financial education as well as judicial vehicle to help out. So prevention as well as dealing with debt. But as I mentioned, this does not bridge every gap. This does not solve every pending issue. So if you are an intellectual, if you're out of that, you're a scientist, you can imagine. Remember, super indebtedness is about consumption debt. What about real credit issues? There are debts of several natures that are not part of that system. And then you have this major gap that needs to be filled. So we are late. We are decades late in comparison to the US. And we need to make the most out of this pandemic time that has catalyzed so many management issues to bridge said gaps. So we have a legislation that's really helping super indebtedness, but we don't really know if it's really going to work, right? Because we're talking about the bare bones, bare minimum things in terms that it's not clear to us. And we also have a law project that is part of the National Congress, which is 12,126, that intends to have a broad opening in regards to court supervised reorganization. So if this is approved, we will have a broader, more encompassing system that is otherwise unheard of or unseen. This was presented in 2005. So from the moment the legislative process concluded, a debate started to take place, and those gaps started to be filled. How to have court supervised reorganization of those people that perform intellectual activities, like I previously mentioned. And also, there is the cooperatives issues, the things that are in debate, associations, agents that could perhaps not be part of that judicial action. It seems to me that this law project, if approved, will enable us to have major advancements to those who are not business people, and even to, business partners that end up in debt because of their companies, because of warranties, for people which we have no means of actually addressing, to give them the opportunity to have this reorganization. And also, hand in hand with Liv mentioned, it's interesting to have this also on a legal sphere, because you're talking about changes which are being proposed, and the suggestion and the possibility of including Article 176C. So that's a new chapter in terms of the transnational one, which was mentioned, brought over last year. And this would extend the possibility of using Law 11,101 to people who are LLCs, minor business people, or people who are not even considered business people, as well as associations and cooperative units. This is about, recovery plans, both legal and extra legal. And this plan cannot go over 36 months for payment, for liquidation. And about also when renegotiating the debt, you could pay up to 50%. So you could pay up to 50% and no more than that. And it's something somewhat similar when we're talking about big business or just regular business. So as we're creating Article 67, the law would then encompass those individuals, those people who have no legal means to solve their super indebtedness. And something that feels somewhat formatted to what we have to smaller companies. You got those 60 days before the plea is sustained, and then you can have up to 36 months to liquidate it with up to 50% discount. It seems something very interesting that deserves our attention. And from my understanding, if this is approved, this will provide room to something that is open. Us, attorneys, lawyers, we do not have a straightforward answer for a person, for the individual who falls into that category. We have no legal means to advise them, to acknowledge that person who acknowledges their financial vulnerability and therefore cannot propose something feasible to them. So now, if that happens, it would conclude the process of the creation of an efficient system for reorganization. So we're talking both business as well as individuals, and thus have the tools, means of an exit to do the math, which allows for those people to come out of those super indebtedness and therefore become assets to the market rather than liabilities. And when I first saw the numbers from Valesca, I was shocked. We're talking about over 60 million people who have no access to credit just because of registration. And many of those will not be catered to by the super indebtedness law, meaning they will remain in that exclusion group unless we can provide them with a more adequate tool. And like I said, this law project seems paramount, seems very useful. So once again, it's important for us to understand where we're at, understand that our system is taking a major step forward. However, it is not a step that concludes a cycle. We need more. We need an answer for that, because there's no way for us to deliver that sort of help that those people so dearly need. Now, let me wrap up by saying the solution did indeed come, but it's not enough. We need to further discuss this theme and bridge or fill those empty gaps so that we can help people. Because trust me when I say nobody goes into debt wanting to go into debt. And that's how legal systems need and should help these people. Thank you so much. Once more, it was a pleasure being with you today. Dr. Juliana Bialchi. That was very nice. Those were many more points for us to ponder upon, to think about the systemics, these new approaches regarding credit systems. I believe there still a long way to go, but improvement is seen. And ladies, it has always been my pleasure to hear you, to listen to you, to see a team so qualified, fantastic professionals. But let me address not only the four of you for this panel, but all the panels that have been here today. They were so relevant. So congratulations to Arwick. I have to thank all of the collaborators here for being so enlightened, for being so sensitive and so sensible as well, how they're dealing with the movement, exchanging ideas, having a debate, contributing to the improvement of the system. And thus we can conclude that the panel theme is about avoiding superindebtedness that has been properly addressed by Dr. Valesca with her numbers, Dr. Leaf that has shown the system, in tiny detail, how to make things operational regarding the new law. Our fantastic, amazing Dr. Judge Sigler showing us, the comparison with the US. Dr. Juliana Bialchi telling us about those gaps that need to be bridged, that need to be filled, as well as things that were pointed out, talking about deadlines, how to retake control of one's life. This is a major topic. It's important to point out, ladies, that this is not about, being cheeky and finding loopholes in the system. This is about upholding the law. But how can we use the law as a means to stop the drain, the leakage, so that people can actually become once more a dignified citizen, complying and upholding the law. You know, she's using the term eternalization, eternalization of debt. For how long will people be in debt? And taking into account the alternatives presented by our panelists, together with the current legal mechanisms that are finally available to us, especially with this brand new law. And I feel that clearly the scope has a very well-established deadline. Like I said, avoiding this eternization of superindebtedness. This is good for both debtors as well as creditors. It's good for both parties. There's still a bunch of debate to take place, and things will improve. Like Dr. Juliana mentioned, time and time again, I'll bridging those gaps. But let me say that this was a very important step, a modernization that was unthinkable some time ago. And unfortunately, I have to wrap up our amazing panel. And for Dr. Vanessa Batista, who honors us, will have now the floor. We're on a tight schedule, unfortunately. And I suggest that, follow the order so that we can go back all the way to our dear Fernanda, who has been following us. And then Tati Flores, our dear director, who will wrap up our panel. You're muted. Let me thank you all who were listening. Very pertinent themes. Let me thank all my colleagues in this panel. I feel so privileged. This was very enriching, you know what I mean? So thank you, Dr. Juliana, Dr. Liv, Dr. Lini, Judge Sigler, thank you so much. Tati, director, and all of you who are backing us up. So thanks so much. And let us keep on discussing. I believe that gaps take place anywhere you have inequality, especially in Brazil, especially when you're talking about race inequality, gender inequality. And there will always be an impact to be analyzed there, especially when it comes to super indebtedness and the need to address this. Let's be more human, as it was presented here before. Thank you very much. Have a great day. On my behalf, I have to thank you all. I learned a lot here today, both about legislation in the United States, as well as the data in Brazil. Very important points brought over by Juliana. And once again, I invite you all to see the Institute and join us if possible. Thank you.
Thank you again for having me join you this morning. It is always fascinating to learn more about another legal system, and it always makes me think really hard about what we can do in the US to improve our own system. So I appreciate the opportunity, and I do hope to be with iWork Brazil again soon.
Well, let me also express my thank you. It was an honor being here with you today. I learned a lot today, definitely learned a lot today. And as I look at the US system, wow, you guys are so advanced, you guys, you become role models to us. And as I can see, Tati, oh my God, we're crawling, we're not even toddlers. But, let's focus on the debate. And I believe we're going to make major improvements. Thank you so much. I appreciate having met old timers as well as meeting new people. And my major hugs and kisses to you all. Thank you so much. Ladies, once more, the floor belongs to Fernanda. And on my behalf, thank you all for following up on us, okay? And okay, the floor now belongs to Fernanda and Tati Flores. Unfortunately, I have to leave. I have to log out. But understand my eternal gratitude for the moment we shared. Congratulations to our WIC. Congratulations, our President, Liv Machado, and to each and every one of you, people working backstage, for that matter, everybody who has come together for this event to be a major success. So, Your Honor, Judge Sigler, you're always, always welcome in our country. Believe us when I tell you, we will be here. I really got to go. Once again, my thorough gratitude to you all. Thank you. Thank you, Juliana, Valesca. Thank you, Judge Sigler. And well, I'll just hand the floor to Dr. Tatiana Flores, Counsel of Advogados and Director of AIC Brazil, so that she can wrap things up for us. Good morning. Actually, good afternoon, I think. I haven't had lunch. If I haven't had lunch yet, then it's still morning, okay? Now, let me deeply thank our sponsors, supporters, especially Insol, and the entire organization team of the event. We took several months thinking and implementing several ideas. Traditionally, I should highlight the current situation and how current those topics are, and how all our panelists were very enriching to us. It all holds true. However, I decided to go out on a limb here today. I decided to do this a tad different. Let me share something with you. Why and how iWork has changed me. Seems like a lot, right? But it's not. In 2018, I was rehearsing to join iWork Brazil. I was double scared of my English skills. You know, it's an association in 70 countries with professionals of the utmost caliber. Can I? Am I going to fit in? Do I have what it takes? So I decided to do a little bit of research about the association on the website. And an article came up, almost like divine providence. It was written by a member called Leisa Blanco. I did not know her, but her words touched me deeply. The article is called The Power of Women Working Together, and it showcases practical tools for us women to work together, support one another, shed light and give voice to other women, and above all, have an active voice. For those who want to read it, it is available in our website. Right then and there, I became a member, almost like an impulse. And I gotta say, I was a tad frightened. However, I was decided to do something different for myself and for my career. My involvement was then visceral. I really dove in head first. I wanted not only to learn, I wanted to belong. So more than a learning area, a learning place, I have found myself in a place where people really receive me with open arms and taught me to overcome issues, especially during the pandemic. During the meetings in which we debated technical themes, but also behavior themes, I was able to identify and learn so much with other people and how they were dealing with this and that situation. This year, we were privileged to take part in a workshop session promoted by our US colleagues on how to have an international presentation, and even better, how to present to ourselves to an international audience. Again, I dove head first and had one of the best feedbacks of my entire life. Posture, I can improve. Intonation, what was I doing that I could fine tune and be better? That was a light bulb moment. Effectively this is a safe environment for myself where I can be myself. And actually, I could be the best version of myself. To be able to live, even if through webinars, with so many professionals in the same area as mine, that is just priceless. And I love it. This event was managed, thought out, and structured in a unique manner so that women would be able to see other women without any judgment, just sheer admiration and respect. Let our iWork transform you as well, because what we have lived here today is but a mere spark of the sheer transformation power that we, men and women, have in our hands. Yes, men are also part of iWork Brazil, and we want more male members. It was a pleasure to meet you. My name is Tatiana Flores. I am a professional under transformation that legitimately wants to learn with you and from you, and who's so proud to be iWork. Why don't you join us? Thank you very much. Thank you, Dr. Tatiana. Very kind words, incredible at that. And I believe most of us just would say, make your words ours, you know. Last but not least, the person who won the kit. It was chosen between the attending members of the last 4 days. And the winner is Dr. Elias Mubarak Jr. So we will grab a hold of him to deliver the kit. That is a wrap. I thank you all for being here, not only today, but throughout these 4 days. You know, keep a close eye, sign up. You know, we're looking forward to having you over, and pay close attention to our schedule, for our event schedule, okay? That's a wrap. Thank you so much, folks. Have a great week and have a great day. Cheers.
Obrigada. Tchau, tchau.
Muito obrigada. Tchau.